So I believe everyone can see my audio as well, can hear me as well. So we have the panel discussion for enforcement and anti-counterfeiting, how to approach anti-counterfeiting in 2023 and beyond. We have the moderator, Krishan Maury Panis. She is the EVP, General Counsel and Public Affairs at Viaccess-Orca, France. We have Girija Varma. She is the certified mediator, international certified mediator, arbitrator, legal counsel, IP expert, India. We have Prity Khastgir. She is the founder and law officer of Prity Khastgir and also the managing partner. We have Krishan, Aniukwu-Managing partner, Stren and Blan partners, Nigeria. And finally, we have Greenleaf, counsel at Dentons, USA. So I welcome everyone for this panel discussion. So before I just reconnect Krishan again, so start this floor and just open this floor for everyone. So Girija, over to you. And as I mentioned, we'll just connect Krishan again. So yeah, Girija, go ahead. Thank you.
Thank you very much, Kiran, for this opportunity. And I also thank IPR Gorillas for giving me this opportunity to speak today to everybody. And I say a warm welcome to all my panelists here. I'm very happy to share this panel with them. The topic that I'm going to cover today is in two portions. The first one will be the remedies available against counterfeiters. And the second portion is whether mediation is a success to address the issue of counterfeiting or not.
Hello, can you hear me? Hello?
We can hear you, Krishan.
Yes, we can. Yeah.
Okay. Sorry. And I see that you have started. I apologize. I could not hear anyone. How do you want to start? Because we prepared a way to scroll this panel. So how do you want to start? Have you started or?
No, I asked Girija to start with her, what she would be covering. So yeah, well, we haven't started, but we can proceed now as per the discussion that you had.
Okay. Sorry for this interruption. I really apologize. I was not in a position to hear anyone. I'm happy to facilitate our panel today, especially that we will have many opportunities to compare enforcement and anti-counterfeiting, whether in India, Indonesia, or Nigeria, or in the US. And one of the reasons there is this panel today is because we all know that the trade in counterfeit and pirated goods is a major challenge to many of us, especially in an innovation-driven global economy. And we also know that organized crime groups play an increasing role in these activities because they directly benefit from counterfeit and piracy. And we know as well that COVID has boosted all these latest trends of counterfeit and pirated goods. And for instance, in Europe, counterfeit account for about 5% of import to the EU. So this is definitively a major challenge. Especially, this is a threat to sustainable business models, and anything that is IP protected, any IP protected product is concerned by counterfeit. In the early days, it was mostly luxury goods. Now it's really business to business goods. It's chemical, it's IP protected products. And we will see with our panel all the various ways where we can handle this question of counterfeit and how it is handled by the various governments, the custom authorities, and how far can technologies help. And in order to do so, I will give the floor as we proposed. I will give the floor to Fajar. And Fajar, I don't know if the presentations have already been made. But, Yes.
Yeah, Christine. So just to inform, due to some urgent issue with Fajar, he couldn't join. He had,
Sorry. And okay. So okay.
but we
Sorry.
have his
Then
presentation with us.
yeah. Then we will move then to Girija. And Girija, you are an international certified mediator, arbitrator, and legal counsel. You're an IP expert. You have been appointed as mediator and arbitrator in many cross-border and domestic disputes. And you are a fellow at Stanford Law School in the US. You wanted to walk us into the civil and criminal remedies available to address counterfeit products. So I give you the floor.
Thank you very much, Christine. And I would like to thank IP Gorillas as well as Kiran for giving us this opportunity to speak. And I say hello to all my co-panelists in this discussion. Yes, I'm going to speak to you about criminal and civil remedies that are available against counterfeiting or products. Basically, I will focus more on civil remedies because criminal remedies are, the normal, generally found remedies that you go around the world, which is complaint to police authorities, custom authorities, and they could be the arrest of the person who's a counterfeiter. So it is a civil remedies, which is what I'm going to discuss in more detail, because it also ties into my second part of my discussion with you today, which is mediating disputes. And as such, broadly speaking, criminal remedies cannot be mediated between parties because it would be the government authority on one side who is enforcing, their orders against counterfeiters. So those cannot be mediated. It is the civil remedies which can be mediated, the civil disputes that can be mediated. So broadly, there are 3 or 4 remedies that are available when you are fighting against a counterfeiter and you're trying to seek any civil remedies. Broadly, these are injunction orders, damages, rendering of accounts, and delivery up of counterfeit products. And the orders that we generally seek under the civil proceedings are, one of the main orders are for injunction, and these are broadly divided into different aspects. The first one, which I will discuss, is the Anton Pillar orders, where a court would appoint a commissioner who would look into the matter. He would go to the site where there are counterfeit products, the site of the counterfeiters' offices or godowns where there will be counterfeit products lying, and they will seize all those counterfeit products, and these will be sealed away and kept away as evidence. So none of the parties can use the counterfeit products any longer. The second kind are the John Doe orders, where again a court commissioner is appointed and he is directed to enter and search unknown defendants. Basically, these orders are against unknown defendants. So, for example, there may be a market which has all counterfeit Gucci products or L'Oreal products are being sold, and there are many retailers. It is very difficult to find each retailer and take an order against them. So the IP owner approaches the court and seeks an John Doe order, which is enforced against unknown parties as well. The court commissioner can enter into any premise, search, and then seize the counterfeit products. And in this, in the court proceedings, each offender is not named. So as I said, it's against unknown parties. The third form is Mareva injunctions, where the assets of the alleged infringer are freezed till further orders from the court. So, if as soon as there's a prima facie evidence of counterfeiting, the court can pass orders and freeze the assets of the offender. Generally, we see in courts, we seek in ex parte injunctions or injunctions after giving notice to the opposite side. Now, injunction would mean there's a stay order against use of the impugned intellectual property, which would be either trademarks or copyrights or whatever the impugned intellectual property is, and also against the infringed and counterfeit products. The court will ask them to deliver up all the counterfeit products, which will then be destroyed if they're found to be counterfeit. Now, these are the broad remedies that are available under the civil law, and these can be mediated. And I think in the second part of my discussion, I will discuss in detail what are the benefits of mediation and how these can be done. Sometimes these are more beneficial than just seeking court orders. So over to the next speaker. If there's any questions, we will take them, I think, at the end of the session.
Yes. Thank you very much, Girija, and we look forward to effectively listening you a second time on mediation. In the meantime, we will switch to a different jurisdiction, and perhaps Kevin Greenleaf is a computer engineer, and you are a patent attorney. You lead Dentons post-grant proceeding group. And perhaps you would like to walk us a bit in the best ways to stop counterfeit, this time not in India, but in the US.
Sure. Thank you, Christine. And it's a pleasure to meet everybody. Thanks for coming. I think that the U.S. processes are very similar to what Girija said were available in India, except that frequently what we experience here in the U.S. is a lot of importation of counterfeit or infringing goods. Patent goods that are infringing patents, and the most efficient way to capture all of those is by getting a general exclusion order at the United States International Trade Commission. And then once you get that exclusion order, then you can block all incoming products into the US because they're typically coming from China or Southeast Asia, and then you can just stop all of them with the general exclusion order. So you, like Girija said, you can identify anonymous parties at the USITC, and then they may or may not participate in the ITC proceeding, and then you get your general exclusion order to the extent that you're able to demonstrate infringement and validity of your intellectual property, whether it's trademarks or patents or copyrights. And you can block all importation of those goods, which is extremely effective. You work with United States Customs to educate them on what to look for infringing goods, and they will just block all incoming infringing products at the ports. That proceeding can be pretty expensive. It can be $1 million to get that exclusion order. So, it depending on whether it's contested. So if you get a bunch of clearly counterfeiting goods, they're exactly the same or they're very close, they're using trademarks that you own, then it's generally going to be cheaper because it's less likely to be contested because there's just no way that they're going to win if they're exact counterfeit copies. Where it gets more expensive is if there are infringing goods that there's some argument about whether they infringe, and it might be a valuable product. Then parties may get involved that are more sophisticated. The Chinese manufacturers are getting more and more sophisticated. One strategy we see often is that you get a few sophisticated manufacturers who say, look, if I can just get my product through the ITC and then they can exclude everybody else, then it's me and the IP owner who get to sell product, and they can get a big benefit from that. So that's kind of a sophisticated strategy that they've been using. And as I said, that can be pretty expensive. Another really relatively on the other side of the spectrum, really cheap way of handling this in the U.S. is, Amazon takes up a large percentage of the U.S. sales because it's just so easy. One-click shopping, and you can buy basically whatever you need on Amazon. And Amazon has an efficient, neutral patent evaluation program, also called Apex. They just changed the name and the process slightly. And that's about a 4-month process where you can submit basically a complaint to Amazon, and then you start this process. It costs you about $4,000 in Amazon fees. If you win, you get that $4,000 back. The accused infringer has to pay $4,000 to participate, and whoever loses has to, the neutral evaluator keeps the $4,000. And so at the end of that 4-month process, you can get up to 20 products called ASINs, Amazon numbers basically, and you can get them taken down from Amazon, and then you can take down other ASINs, and that can be extremely effective because these infringers find a lot of value in their Amazon ASINs, because those are web pages that they've developed and cultivated by getting reviews. If they have 5-star reviews, they've sold thousands of products, they have thousands of reviews. That's extremely valuable because they'll get page ranked really high and sell a lot of product. So if you can get that excluded on Amazon, for really much less money than an ITC proceeding, that could take out a huge chunk of the sales in the U.S. So those are two, of the really effective ways of doing this process. As Girija was stating, we have similar processes in the United States district courts, but those are also very expensive. They're less effective, and really only useful if you have, a small number of importers. But typically, what I've been dealing with is you have large number of importers, a large number of infringers, and in that situation, you want to go to the EITC, and then you may want to go to Amazon because Amazon is so cheap and efficient. You can do both of them.
Okay, very interesting. Thank you very much, Kevin. And I propose now that we have another view from a different continent, and perhaps Christian can share with us his experience. Christian, you are in Nigeria, and you are the managing partner of Stren and Blan, and you have the IP prosecutions and anti-counterfeiting department. Perhaps you could walk us through your experience with the growing counterfeiting activities on e-commerce sites.
So Christian,
thank you very much.
Christian, before you proceed, can you open your video as well for the other panelists and the participants?
Oh, I have done that, but I don't know if you can see me.
No, we can't see you, but have the same issue. I cannot open my video.
Okay, no, we can hear you. You can proceed, Christian.
Yeah. Go on, Christian. So you wanted to share with us your experience with the growing counterfeiting activities on e-commerce site, right?
Yes. So I will be sharing my experience working in Nigeria, having handled a lot of e-commerce infringement on the e-commerce sites. So historically, I think this started with COVID. So prior to 2020, when COVID hit, a lot of counterfeit activities were ongoing at the brick and mortar markets, right? And that's where you go to the market and you see a lot of counterfeit products, and you work with regulators to conduct raids, seize the product, destroy them, and the rest of them. But basically, before then, people felt that purchasing products online or via all the e-commerce sites, especially the B2Cs, were much more reliable. It's much more reliable to get genuine products online. But when COVID struck, major commercial activities shifted online because of lockdown. So people got, started getting a lot more of their purchases online. And what that now also did was also to make the counterfeiters also go online to sell their products as well, of course, to also reach their customers. And now led to an influx of counterfeits on the online space. And the funny thing is, aside the big online, stores that we have, at least in Nigeria, we have two major e-commerce sites. Aside those ones, people also create their sites, links on Instagram, on Twitter, on even WhatsApp status, even TikTok. People advertise and sell products, making it having so many avenues for the sale of their products. And like I mentioned, that also led to high counterfeit activities going online. So of course, brand owners now also shifted their attention to the online site as well, aside the brick and mortar market. But the thing you find out is that anti-counterfeiting actions or strategies on the online space is far different from what you see when dealing with those at the brick and mortar markets, right? It's more difficult dealing with counterfeiters on the online space for various reasons. One is the anonymity. You don't get to see their real names or their company name. They just use, some pseudonyms or aliases to sell. And it's for two reasons. Basically, from my engagement with the e-commerce side, they don't want the consumers to know who is selling, so that you don't divert the business to the offline space. Oh, if you know that this is this person, then you'll be like, why now spend the money paying for the logistics of transportation, and why not just walk down to the person's store and get it, right? So that anonymity is a problem, because when you're fighting them, you don't even know who you're dealing with. That means you have to go through the e-commerce site itself. And then another problem is that the e-commerce sites, they are not too cooperative. They don't cooperate so much when you are dealing with these guys. They are trying to protect their businesses and the rest of them. So most times when you write a takedown notice or cease and desist letters to them, they have their own defense. They will tell you, oh, the safe harbor defense, that we are not the ones dealing in your product, so we are not liable. Then, of course, we know you are not the one dealing, but there are some guys using your platform to, do all these things. So we want you to take it down. So most times they don't cooperate. They are too lackadaisical or nonchalant about the counterfeit activities. So making it a bit difficult, and we, the lawyers, trying to take.
Yes, I will take it forward. Thank you, Christian, for mentioning all these difficulties in the days of Web 2.3 in trying to do something against counterfeit and online, especially in online world on e-commerce sites. And I think that going from Web 2.0, we will be going to Web 3.0. And I will give the voice to Prity. Prity, you are the managing partner of TechCop International Strategies. You're headquartered in New Delhi, India. And you are IP tutor for blockchain and AI patents at WIPO Geneva. And what you propose today is to give us some insights, in terms of the future, in terms of the metaverse on the Web 3.0 this time, and you would like to explain us how can creators and users of virtual content navigate the evolving legal landscape of IP in the metaverse. So that's a true subject, and we give you the floor.
Thank you so much. So I would like to deal with this question in two parts. First of all, we need to understand who are the creators and how the creators can understand what IP is all about. So the creators economy as such is $200 billion. And due to Web 3.0, metaverse, and other technological aspects which are coming online for the very first time, it is a $1 trillion economy. So understanding the economics, it's very important to understand the intellectual property rights associated with any business model. So when we talk about metaverse per se, and when a creator is coming on the metaverse, there are many creators who are filing for intellectual property rights in terms of trademarks. And when I talk about trademarks, trademark becomes of prime importance, especially in Web 3.0, because trademark is all to do with branding, how you create your brand, taglines, logos. So filing trademark in multiple classes becomes very important, and especially in the metaverse, right from class 9 to class 35, 41, 40, 36, 38, 42, which is to deal with the service industry, because in the trademark classification, the set of classes which is dealing with the goods, and their set of classes which is dealing with the services. Even in the metaverse, education has a different class. So filing the trademark is very, very important, which is very prime. And what has been seen from the past, and I'm talking about the landscape of last 20 years, there have been creators who understand their IP, they file for a trademark, and then they're creating something in the metaverse which is owned by a third party. So when you're creating something in the metaverse, and then you say that this is my brand, so there's a lot of litigation which is happening. So what is prime here is to create a pool of technologies, a pool of brands where you can have licensing. And licensing can be the cross licensing. Say, for example, a creator or a user comes to a metaverse, create something, maybe related to food, maybe related to music, maybe related to art. So what needs to be done is to get these technologies on a blockchain in the metaverse, and then pay a royalty and use it. So that the whole idea of intellectual property rights is it should reach the masses. So co-creation is very important. Along with that, sensitization is also very important for the creators to understand what are their rights when they're coming in the metaverse for the very first time. That is one thing. Another very important thing is the machine learning which is happening behind the scenes. Whether that machine learning, which we call in very simple terms, is artificial intelligence. So artificial intelligence for the very first time was introduced in the year 1956 by John McCarthy. So it was a project at that point of time. The only thing why today, when we have termed this Web 3.0, and especially if you see the landscape from 1999, and right now if we see the timeline, we are in 2023, what has been seen is a lot of data has been created. So AI needs data. It has to be data fed so that it can identify patterns. Again, when we talk about artificial intelligence or machine learning per se, basically, in very simple words, one is supervised learning, where there's human intervention, and another one is unsupervised learning, where there's no human intervention, which means the output is not fed to the artificial intelligence. And a very good example of the current talk would be ChatGPT, in terms of which is a supervised learning, where the user or the creator is trying to ask or prompt a question, and the AI is trying to tag that question or whatever prompt into a tagging process, and then analyzing the data which is being fed on a regular basis and giving the answer to that. That is one aspect. Another very important aspect when we talk about metaverse Web 3.0 is smart contract. Now, how smart contract can be deployed in the metaverse is the question we all need to answer, not only in the terms of creators and users, it is also the people who are creating the metaverse, or who are responsible at the back end to create the metaverse. So in all contracts, and Girija ma'am also talked about it, the mediation part. What is very important in any kind of contract is the dispute resolution clause, because we talk about NDAs, any contract for that matter. What is important here is to analyze when we see the dispute resolution clause. Earlier, the simple clause of dispute resolution was arbitration. However, things have changed, and especially in last one decade, what has come, the new thing is the mediation. However, the dispute resolution clause can be broken down into three major aspects. First could be the negotiation, second is mediation, and third is the arbitration with the timeline. So the basic of dispute resolution clause can go into a smart contract. However, smart contract itself should be hybrid. Now, what is the concept of hybrid in a smart contract, especially in terms of Web 3.0? So a part of the contract which can be coded is smart contract, and the part of the contract which has to be done in the traditional way where the parties sign it, it's notarized, and then the other aspects are taken care of. So that is something we need to see in a smart contract: what can be coded, what cannot be coded, and how to draw the line between the two. Another very important aspect is to understand the use of copyright material which is being created in the metaverse. Who owns the ownership of a copyright? Generally, when you are entering into any arena of Web 3.0, and when you click on the accept button, or the tab which is there generally on these Web 3.0, since the user doesn't know about it, whatever intellectual property rights will be created would be owned by the the metaverse owners. So that sensitization has to be done, because once the sensitization is done, then only the stakeholders globally are going to take some kind of action, because in Web 3.0, jurisdiction question becomes, impertinent in terms of where the data is being stored, where it was executed, where was the company, running from, whether it has a sister concern. So there's zillion questions, but a framework has to be developed when we talk about how the rights of the creators and the users can be, kept in view of protecting the intellectual property rights and co-create at the same point of time. Thank you.
Thank you. Thank you. This is a major subject, and this question of the metaverse, and we see that we will have to proceed differently on an IPR point of view. And one of the things as well that we shall see is that it will certainly bring some evolution in a lawyer's life, because when you talk of smart contracts, then not all of us know how to code. And this will be a different expertise as well. I think that that will be necessary. I will now continue this this panel, and I'm wondering if in the meantime if Fajar has joined. Not. No, I don't think so. So then I will be back to you, Girija, because you will certainly like to share the second part of what you wanted to tell us today. We started talking about mediation, and how do you see mediation in enforcement and as something in anti-counterfeiting? Is it a successful tool? What are their benefits?
Thank you, Krishan. So as we can see, I think we are all in the rat race where there are smart contracts, technology is going ahead, e-commerce websites are coming up, and the law also is changing according to, I think, the new scenario. So mediation has been around for many, many years, but I think recently it has gained a huge importance because Singapore has signed an international convention, and India is a party to that convention where they are promoting mediation. And I think COVID also turned us all towards this new form of dispute resolution, where we find many benefits in mediation. And that's what I'm going to talk to you about today. Now, first, I will just give you a little bit of the flavor, taking from what Prity said, that, and Kevin also mentioned that, there are many issues also in court processes. As Kevin mentioned, it's a very expensive process to go into court and get orders. It could be running into millions of dollars. And so mediation is found to be far more cost-effective and an efficient form of dispute resolution. It's quicker and it's more creative. It is a solution that parties find between themselves with the help of a skilled mediator. And it has many benefits to it, because not only they can find a creative solution, they can also rebuild a relationship. Now, yes, who would build a relationship with counterfeiters. The issue is actually that counterfeiters in the market are basically the same retailers or the marketplaces where larger companies sell their products, and they all work off each other. They all are in the same business actually, except that the counterfeiters are doing illegal activities. So what we have seen through the court process has been that when we are seeking civil remedies, there are some limitations, one of which is jurisdictional issues, as Prity had mentioned, that there are many jurisdictional issues that can arise. And mediation, which is done as a cross-border mediation, actually does not touch on the jurisdiction issues at all. We see in courts, we could be fighting a battle for many, many months and many, many years over jurisdiction itself. So that clearly gets reduced in a mediation process, because you could do a cross-border mediation. There are no jurisdiction issues about it. Of course, there could be enforcement issues that could arise as to where the settlement would be enforced and how it would be enforced. But a skilled mediator would generally ensure that even the enforcement is taken care of while the parties are negotiating with each other about the counterfeiting issues. Second issue that we've seen is that in enforcement issues that we face in civil remedies before courts are that you are dependent on the government bodies and authorities like the police, the custom authorities, the court commissioners to seek any kind of remedy. So sometimes that can be a challenge to quicken the process or to even find your remedy correctly. Sometimes you're largely dependent on government authorities for your resolution. So mediation is seen to be effective because you are in control of your case and you can find ways within the mediation process to find ways to address issues of how are you going to deal with the counterfeit products, how are you going to destroy the counterfeit products or retain them or use them. That can be easily done in the mediation process. Third point is that mediation is a highly confidential process. And if that was not there, I don't think there would be any success to mediation. So in my experience, when I've mediated many of these IP issues, I've noticed that during the process, you can bring the parties in a position where they are more amenable to each other. And then they are willing to reveal information which they would not be able to do before any court, which is the source of the counterfeit products, which is very, very important because we see over the years that counterfeiting is also becoming more organized. It was not so earlier. Earlier, we would see only fly-by-night operators. We continue to see those even now, but there's also organized crime. So during the mediation process, we can ask one of the parties to reveal the source to the other side, and all of this can be kept confidential. Otherwise, if this was not available, we would need to seek the Norwich Pharmacol orders from the court, which are extremely difficult to get those orders because it is very difficult to obtain third-party information, which is where the source is, who are the retailers involved, who are the manufacturers involved, who are the distributors involved in the counterfeit products. So this is a good way in which mediation helps the parties to find this information. And I think largely I feel that these points help the parties to find creative solutions. They could find, even if they're counterfeiters, if they're willing to destroy the counterfeit products and find a resolution, and the IP owner could condone their illegal activity, and then they could have a business arrangement as well. So in my understanding, I think mediation has a much larger canvas than any other form of dispute resolution. Thank you.
Thank you. Thank you. I think you're very persuasive. Yes, indeed. It seems to have a lot of advantages. And also, as you say, confidentiality, as you say, we don't care cross borders restrictions because it can be applied anytime, and it's certainly closer to the business, more helpful in finding an economic situation as well, a solution. And I think that yes, definitively you are right. Is it widespread now or not that much?
It is not that much as it should be. It still is in much lower numbers because parties are still not convinced that mediation is a good process. And whether that, there are also many egos involved. Parties are not willing to come to the table to negotiate. But we are seeing the numbers increase every day. I think and they have been extremely successful in intellectual property matters.
Thank you. And in your experience, how long does it take, in average, a mediation? Is it definitively shorter than a case, a lawsuit? How would you compare here?
Absolutely. I think in my experience, I've seen that litigation would the shortest probably litigation in court would be from about 4 to 5 years, where evidence is led, discovery is done. And in mediation, we've seen success. Probably 6 months is the longest that we've gone. There have been mediations which have concluded within just 2 to 3 months. There is also a timeline that is given by the mediation rules, which is about approximately 6 months. So I think the timelines are much, much shorter and the costs are also much lower.
Thank you. Thank you very much. That was very interesting. And now I will give the floor to Christian. Can we hear you, Christian, now? Christian?
Yes, please. Yeah, I think it's better now. I had
Yes.
to refresh. Yeah.
Okay, that's good. I know that that there has been an experience shared with mediation, and there is also another experience in having cooperation with customs. And you wanted to tell us how effective has IP records with customer been in the fight against counterfeit products. So the floor is yours.
Okay. So I will state this. So one of the problems, using Nigeria for an example, one of the problems we encounter in generally fighting counterfeit products is the issue of lack of specific legislations, right? So because there is no specific laws on so many things, even on fighting counterfeit on the e-commerce side and the customs aspect, lawyers keep engineering the existing laws, interpreting it progressively, and trying to convince the regulators, to think progressively, to adapt best practices internationally. So there is actually no law making provisions for customs record, IP recorders with customs, Nigerian customs in Nigeria, for example. So, but what has happened over the years, not too old, maybe from 4 years back, it's have come together with lawyers in the IP space to form a collaboration, an association that is known as ACC. And one of the solutions we've adapted is to do what we call customs training. It's an annual event where you have the opportunity, any interested brand owner, it's not compulsory, to come together, fix a date, have an opportunity to train customs, tell them, apart from the general topic of talking about counterfeit and how dangerous it could be, you train them on how to identify your genuine products and how to identify the fake. These are the features in the genuine products. These are, anything you see, or these are the types of fake you've seen previously. It can never be exhaustive because, the counterfeiters keep changing their styles and their motives, right? So at the end of this, we will now do what we can tag customs recorder, a manual, or a quick a kind of a manual to customs to help them to easily identify these products. They have your contact person, because by legislation, custom doesn't have the power to seize a product beyond some hours. So you register with them a particular contact that when they flag a shipment that they feel contains some counterfeit product, based on what you've told them, they have somebody to quickly call. So preferably someone in Nigeria that can quickly call to say, oh, can you come at this port or that port to check out this consignment or this product? And when it is done, if it's counterfeit, it will be seized and they take it up from there towards prosecution and the rest. If it's fine, it will be released, right? So this is like one of the solutions that the practitioners in Nigeria have come up with. We have our we have other African countries that are explicit, express, and very beautiful provision when it comes to record of customs. For example, Kenya authorities, they have a legislation on that. You have to record your IP rights with them. They have to go through the proper checks. Shipments have to go through the proper checks before they are released. So with that kind of legislation, they have a watertight process for admitting goods inside the country. But for us in Nigeria, what I've explained is like how we do it. So you have to work with regulators and be on constant watch service. If you have any intelligence, relate to them. And with the informal record out I described, it has actually proven to be a good, at least it's something rather than nothing. It's a good method that we've been able to, fight counterfeit products from coming into the country.
Thank you. Thank you, Christian. And we are going to our next speaker. I think I will have to have an issue again. No, that's good. The sound is good again. So I will now propose to Prity to bring us back to this metaverse and at least to the future, and tell us a bit more about blockchain and AI-driven technologies. How can you integrate these technologies? How can they be used to combat counterfeit, while at the same time protecting intellectual property rights? And then when doing so, you will describe us the key considerations and challenges that must be addressed before we can ensure the effective implementation of these strategies. You have the floor, and please walk us into these blockchain and AI technologies.
Thank you so much, Krishan. Blockchain AI is very close to my heart. I have been already working, writing patents, I think since 2007, 2008, I've been writing patents in these technologies. Coming back to the point of watertight contracts. So you can see blockchain as a watertight contract, or you can see blockchain as, fencing intellectual property rights, because blockchain is a ledger where it cannot be hacked per se. Now the billion-dollar question is, like, many a times you might be reading in different articles, there's something called as DAO, which they say that it's an autonomous organization which will take care of everything, even the mediation, everything will happen automatically. That's what it's promising. But coming to the logical part of where we are today in 2023, is basically we need to understand that AI, that is the artificial intelligence, can be utilized for the counterfeiting. How it can be done is, especially in the fashion industry, the products which are created and different intellectual property rights are filed. So if I take a fashion product for an example, which may be a contour dress, now the dress per se would be registered under industrial design. That is one intellectual property. The another thing could be the machine which is utilized to stitch that particular contouring dress. It's new, novel. So in that aspect, that will be the part of patenting. Then the third aspect would be the trademark, how the trademarking is done. Say, for example, Louis Vuitton or other brands which create intellectual property rights, and they spend a lot of money just to stop the counterfeiting. So what can be done in that case is utilize the AI, which is the artificial intelligence, the algorithm will identify the products. And now the thing is, as humans, we live both in the online world and offline world. So what will work best, at least in the scenario of next 10 years, would be a hybrid model. So when I say it's a hybrid model, what can be done in the current scenario is putting a QR code, which is a scanning code with the product. So as a customer, as a user, the user and the customer has to be sensitized through different means, and the stakeholders are going to play a very pivotal role, where you scan the QR code of any product, and since the QR code is dynamic in nature, so when you are utilizing the algorithm of dynamic, it means it cannot be muted, it cannot be hacked. In that case, what will happen is the AI is going to, it's like HACCP. HACCP is basically hazard analysis critical control points. So whatever the leaky pipelines are there, and here the intellectual property people, whether they are lawyers, whether they are engineers, are going to play a very pivotal role. Now, why I say it's going to be a very pivotal role, because the leaky pipeline is going to change after every, maybe a quarter. Because what happens in the blockchain is there's an algorithm which is being developed, and something is called as proof of work. So if I talk about application of blockchain is in a cryptocurrency, that is one application, and one application of that is Bitcoin. It's one application. Most of the people or the folks think that blockchain is all to do with Bitcoin and financial sector. No, blockchain is a technology which is built over the communication network, where the proof of work of Bitcoin is approximately 9 minutes. So what now people who are into the coding world, which is known as the dark world also, they hack between that proof of work of maybe 9 minutes, and that is the time when an AI can be deployed to track the different supply chains. So that is one example. Another thing which can be done in the current scenario where AI is being utilized, especially for the copyright purpose, is to bring the metaverse and other technologies in the online world, and have that caveat of protecting the copyright by paying a royalty. So their smart contracts have to be deployed. So if somebody wants to use a portrait or something, you pay the royalty and then you put a layer on that. So in the real time, the creator is able to monetize what he has created. So what I see and propose and see in next couple of months would be that the loyalty program will come online for the very first time, and that's the way these litigations which are happening in the copyright and AI, who is the creator, would be sorted out. Thank you.
Okay, thank you. Yes, there is a big hope in all these blockchain and AI technologies, and this is the same with the EU Intellectual Property Office. There is a big hope in that, but I must say that up to now, this is not very widely used, unfortunately. So we head to the end of our panel, and we would like to give the last word to Kevin. Kevin, you had you raised a point, and that I would like now to raise with you. If you're a knowledge counterfeiter, what are the best ways to defend yourself? So what could you say?
I was looking at that question I gave you, and obviously I can't give legal advice to criminal activity. So if you're an obvious counterfeiter, then you're obviously in trouble. And you just can't counterfeit goods and sell them legally in the United States. But let's say rather than a exact copycat, you are using a patented technology, or potentially alleged to be using a patented technology, and you're in the International Trade Commission. You think you're product is different from the patented technology, or you're at Amazon and you think your product is different from the patented technology, you can obviously defend yourself in the usual way, which is, you know, asserting the typical defenses and those proceedings, saying I don't infringe, etc. You know, the Amazon proceeding is very quick and cheap, but they only determine whether you infringe. So there's no invalidity analysis. You can get out of the Amazon proceeding by filing what's called a declaratory judgment of non-infringement in a U.S. court, and then Amazon will just defer to that proceeding, and then that can tie you up for a long time, depending on where you file your declaratory judgment suit in the United States. So you could file that declaratory judgment suit, and you could also challenge the validity of the patent at the United States Patent and Trademark Office. And that's my particular area of expertise, even though I do pretty much everything in patents, but my specialty is in the administrative proceedings at the patent office, where you can invalidate a patent relatively less expensively, but it can still cost upwards of $200,000 to $500,000 to challenge a patent at the USPTO. But if your product is, you know, successful and you think you have a good challenge at the patent office on this patent, then, you know, it might be something you'd be interested in, is challenging that patent, and then you go through an 18-month process. And in the meantime, you may get a stay in the district court litigation, and so the Amazon proceeding will be kicked out. And you can also do that with a parallel ITC proceeding. So, you know, the law is changing frequently regarding these patent office proceedings. So it's good to get a skilled attorney who knows this area well, because it is about, let's see, 11 years old now. So it's not too young, but still there's constant talk about how to change it, and you know, with different changes of administration, the rules change. So it's highly fluid about how those proceedings go, but they can be relatively efficient compared to U.S. district court litigation. And if you're in a parallel ITC proceeding, which moves very quickly, 18 months or so, so it's about the same as at the patent office, you can get multiple bites at the apple. So if you lose at the ITC, but you win at the patent office, then, you know, you could ultimately win. So there are complicated parallel proceedings and different ways to attack these problems if you're accused of infringement, particularly patents, to defend yourself. So you don't just have to take the most obvious path. There are definitely sophisticated strategies you can engage in.
Okay, thank you, Kevin. Just quickly checking if Fajar has appeared in the meantime. No.
No, Christine. So you can see that in the Q&A session, Lubika has wanted to add what Girija has shared her speech, that she would like to add what Girija said about the benefits of mediation. Another big advantage of mediation is that it allows for the consolidation and joint resolution in one mediation procedure of several disputes that otherwise will require separate actions in different jurisdictions. That's what Lubika has added.
Thank you.
Absolutely. Thank you.
Go on.
No, absolutely. That's right. There's an addition to the point. Thank you.
Okay, perhaps we may go to the Q&A session. If I don't know if questions have been raised in the meantime.
I have a question for Girija. You know, where do most of your clientele come from? Are you mostly representing Indian entities, or do you frequently represent entities from the United States or Europe or other parts of the world?
Well, it's both. There's a large chunk that comes out of India, they're all, from the court sent mediations. And then there is a large part which comes as cross-border. I've done between pharmaceutical industries, the patent holders in the US and the generic pharmaceutical companies in India. And same goes for construction industry. So they are cross-border as well.
Other questions within the panel, and then we can see if there are questions among the participants.
Right. So I would request everyone, the attendees who are listening to this panel discussion, to share the questions on the Q&A tab, and you can redirect your questions to anyone. So please, there is a chat box on Q&A, and you can raise your questions here only, and so that Christine can take up the question. So in the meantime, Christine, yeah, if you wanted to add something on what the panelists have shared.
No, I think that this has been a very big tour of the possibilities of approaching anti-counterfeiting, whether in our concrete world or online, or without talking of Web 2, Web 3.0. So with an already a good idea of how we should more react and readapt our way of rethinking IP and IP enforcement in the metaverse. So I think that that was very useful. We also are now persuaded, I'm sure, that mediation is definitively a good way to handle these cases, and certainly not widespread enough. And we have some good guidelines in terms of what could be used in terms of the new solutions like blockchain and AI-driven technologies, despite I would be a bit more restrictive for AI-driven technologies, because actually it can play both sides. They can also foster and help fostering counterfeit and piracy. I see that in the world of piracy because I'm dealing a lot with piracy, and this is kind of double weapon, because it can help, but it can also spread it much more largely, and that's the case of all these new technologies. So I think we have had a very nice overview. We regret for for Fajar, who could not share with us his experience of Indonesia.
So, Christine, just to let you know, I believe Fajar has shared his presentation as well. If everyone wants, then I can share that. This can share the screen, and you can all see the presentation that he has made. So,
yes, we can benefit from it. Yes, certainly.
Yes,
certainly.
I think you can see this, if I'm not wrong.
Yes, well, I'm not sure I'm the best one to walk
so can you
everyone.
See this?
I think that he wanted to share with us kind of obstacles of recording trademarks and copyrights at Indonesian customs. So I mean, it's quite. I think that the best, perhaps, what could be done is that he gives a little bit more input on his slides, and then you share the slides with all the participants, because I would not like to make errors on the messages that he wanted to convey. So I prefer him to convey these messages.
Yeah.
Do you want to go to a Q&A session with the participants, or do we have a bit more time? Because what I was foreseeing,
we have 10 minutes. Still.
We have a bit more time.
Yep.
Because what I wanted to do is to share with all of you, with the panel, of course, and with the participants, an experience that I have on another type of counterfeit of IPR infringement. And this IPR infringement is less known, and people don't want to hear about it because that's very popular, and perhaps many of us are doing that. But this is another example of IPR infringement and how we can take this kind of infringement, how we can handle it. And basically, I'm the general counsel of an affiliate of Orange, and our company is supplying technologies that are used by right owners or by pay TV operators so that their content is protected, but is also consumed when you want, the way you want, on whatever device you want. And these what our customers, who are mostly streaming platform, legal streaming platform, or pay TV operators, for instance, or right owners, what they are suffering from, and you certainly heard about it, is illegal streaming, which is a real case of IPR infringement. And this is something that is being severely looked at by the EU Intellectual Property Office, but not only, also by Interpol, because exactly the same for counterfeit of products. There is a lot of organized crime behind this, and this has become a very critical point. It was already before COVID, and as most of counterfeit, it has been unfortunately boosted by COVID, especially for online activities. And the situation is in Europe that, for instance, this is a big loss for TV companies, because they estimate, for instance, that they have been losing over 3 billion euros in Europe in 2021 because of these IPR infringements, because of these illegal streaming. And this is quite widespread, because this corresponds to let's say 17 million people in the 28 countries of Europe, meaning that this is 4.5% of the population. So in other words, 4.5% of the population in Europe is using this IPR infringement to get access to contents that are protected content, and normally you should pay to get access to them. And the UK is one of them. This is quite high in the Netherlands. This is quite high in France as well. And what is a shock also is that sometimes the EU Intellectual Property Office conducts what they call IP perception study, because in all these cases of counterfeit, whether pirated products, whether counterfeit product, then the very first question that you have to ask yourself is, how far are people aware exactly of what they do? How do they perceive IP? Do they understand it? And so forth. And now all the latest IP perception studies show that they understand this. They and in terms of, for instance, illegal streaming, they accept it. They think that this is acceptable. They have a very tolerant attitude, and this is also one of the big points in terms of IP infringement. This is true for counterfeit as well. People, unfortunately, tend to see this as normal now. So this is not only, you see, a question of illegality of whatever. This is also very much a question of mindset, and this is also what makes it difficult to fight these sorts of infringement. So of course, there is legislation to combat this sort of counterfeit, because legislation has adapted, especially in Europe. You may have heard about all these Digital Market Act or Digital Service Act in Europe, and what they are trying to do is, of course, to try to create a safer digital space, to respect all the rights and to make sure that innovation and growth can take place. So what they have done is that they have been introducing kind of new sets of rules for, especially for online intermediaries, and then, they have increased responsibilities, and to limit these illegal content and illegal products in general. They have created new rules, and they have increased the notion of accountability. And these rules should normally start taking effect as of 2024. So let's hope that they will give more responsibilities on the platform. For instance, they will be obliged to conduct regular assessments on their platform to assess these sorts of activities and how they react to that. So normally this should help a bit. We to have in Europe more and more countries adopting blocking injunctions. This is true for illegal content. This is true for counterfeit, and normally you should be able to get very quick decisions against all these sites. You have more and more dynamic blocking injunctions, and this gives you more flexibility, for instance, to cover repeated infringements. So you are not obliged each time to request a new injunction. This works for several repeated infringements, and you have also now, this is all the more important for contents, you have these live blocking orders, which allow as well for the repeated blocking of a site every time a live broadcast is in process. So these are major steps that can be a good way of fighting counterfeit or IPR infringements in general. And this is very much put in place not only in Europe, but there are many countries in Asia as well that are adopting this. I'm thinking of Indonesia or the Philippines or Thailand as well. You have also new laws that try to facilitate the role of a judge by establishing a kind of authority that will instruct all the case, and then the judge will deliver the injunction, and then that authority will be in charge of making enforcing it. And this is new as well. We have this in France with the creation of ARCOM, and then normally once the decision is made by the judge, they are in charge of enforcing it. And this has given very good examples. This is a bit what is the landscape for the time being to fight against this sort of IP infringement. You have technology as well. We discussed it for counterfeit. This is exactly the same here. You have, all these algorithms crawling the internet and looking for the links bringing to infringing sites. And I'm sure that many of us or customers have this. And it allows you to quickly de-index certain of these links, or you can remove them as well, depending what sort of agreement you have with the platforms. So this is also a help. We also use a lot artificial intelligence. The point is that in this sort of infringement, there is a new wave of infringements that for the time being is not covered at all, nor by any legislation, nor by any technological means that could help in fighting them. And I'm talking of the specific question of the apps. I'm sure that we all know that it's easy. You just download an app, and the app gives you access to whatever protected content, either for free or for a price which is much better than your subscription. And then, this is a huge, this has become one of the new recent infringing model, and it's a very difficult model because an app, for instance, is downloaded at least 50 million times. So you imagine, even if you go via a process after to ask the store to take out the app from the stores, once it has been downloaded, it stays downloaded. And with these big amounts, then you can imagine that this is definitively a challenge. So where the challenge becomes even bigger, and this is something I wanted to mention here, is that more and more, all of this not only is linked to organized crime, we all know that, but this is linked to cyber attacks. What we have seen in the course of last year, and there are many studies now confirming that in the US, in Europe, what is very clear is that it is not rare that once you've downloaded one of these apps or gone to a site selling counterfeit or gone to a site selling pirated content, then you have a big likelihood after to be subject to ransomware. And this is more and more the case. And not only ransomware, but the risk is also that, of course, your credentials be stolen. And this is a very high risk because some studies estimate that nearly, for instance, 80% of pirate sites serve the malware-ridden ads to their users. So this is just to call the interest of that. Behind organized crime, there are also serious risks of cyber attacks when you go to these sites. One of the difficulties as well of fighting either counterfeit or piracy is that, this is well organized. As we said, this is organized crime, but these are huge ecosystems, meaning this is not a question of you and I just downloading the app or buying counterfeit product or whatever. This is all organized around that. You have the consumer, you have the ISP, but you have the app stores, you have the domain names, you have the payment providers, you have the ad servers. So you have all the social media and the platforms, meaning that this is also increasing the complexity of how to handle the situation, because you have to go to all these stakeholders if you want to do really something serious to go against counterfeit and piracy. And also the last part is that there is also many things to be done with the consumer, because as I said, in the IP perception study, the consumer does not perceive this as illegal or knows it, but thinks that this is acceptable. And then you have also mixed ones. Just like you can buy clothes from a brand, or you can buy counterfeit. This is exactly the same for piracy. You can have a regular subscription, just like you can stream, because it's the way now to consume content. So this makes all these environments that we've been describing in terms of counterfeit, this makes it all the more difficult, because it's a question of mindset as well, and it's a question of huge ecosystems that are behind, and not solely a question of who the counterfeiter is and who is the consumer. This is just what I wanted to add to our panel.
Thank you so much for the insights, Christine. And I believe it's a very intriguing session that I believe all the participants and the attendees have enjoyed it. And so before we close this session, I would request Girija and Krishan to open your videos, respective videos, so that we can capture this moment. Krishan?
We see you.
So please look into the camera and smile and yeah. Thank you so much. Thank you so much, everyone, for sharing your insights on this panel. So